May it please your lordships, I appear on behalf of the appellant, Mr. Fiona George, in this matter, with Mr. Godwin Busuttil, and Mr. David Price of Queen's Counsel appears on behalf of the respondents, Linda Cannell and LCA Jobs Limited. My lords, if I could very first briefly outline what happened at the first instance trial before moving straight on to the construction of Section 3.1 of the 1952 Act. The first instance,
of course you can. We have read the papers.
Yes.
But, yes, okay.
Yes, I won't
In headline terms.
dwell too much on what's in the skeleton argument. One thing I did want to make clear was it's obviously apparent from the judgment that a draft judgment was delivered which found in favour of the claimant on liability.
Yes.
And then things switched. I won't say anything that isn't in the public judgment as handed down. But what's important to note is that on the final day of the trial, the judge indicated that he wouldn't hear argument on the issue of quantum because he would hold another hearing on quantum if it would be necessary. Therefore, the court at first instance hasn't heard full argument on quantum. After that, clearly he gave the first draft judgment in favour of the claimant. He changed his mind, of course, he's entitled to do. But then a further draft judgment wasn't given. He proceeded straight to handing down a final judgment, which included the reversal of the finding on liability.
What point do you make from that?
The real point I make, forgive me if I do stress it during this hearing, is there's been no decision on quantum and no proper argument on quantum. On the facts of these cases, there can be a blurring between what's properly considered as quantum after publication and the likelihood of pecuniary damages at the time of publication.
All right. I'm not sure where that gets you, but...
Well, very well. My Lord,
I suppose it may be relevant to this. One thing that occurred to me as a comparative novice in this field is I wasn't quite clear what the claimant was in fact seeking by way of quantum on the facts as found.
May I deal with that in due course?
Yes.
And that is something I'm going to deal with at some length.
Okay. Right. Anyway, we have your point. There was argument about the need for
there was full argument of liability,
but not about what the quantum of damage would be if it were available.
Full argument on liability, not full argument on quantum.
Yeah. Okay.
Turning to Section 3.1 itself, I just rely on the quotation at paragraph 1 of our skeleton argument. Our submission, that's page 24 of the core bundle, tab 3. Our primary submission is that this is not an ambiguous statute, and it does exactly what it says it's doing. It says, Section 3, paragraph 1, effectively in an action for malicious falsehood, it should not be necessary to allege or prove special damage. So that differentiates it from the common law claim, where one must prove special damage in order to establish liability. And then moving on to subparagraph 1a, if the words upon which the action is founded are calculated to cause pecuniary damage to the plaintiff or published in writing or other permanent form. Now clearly, again, that's obvious. That's referring to a written or permanent communication. Calculated, it's been a matter of agreement in this court, and we don't seek to overturn it, but calculated means likely. In that context, it means more likely than not.
Hang on. So you say common ground, it means more likely than not.
Yes. And the focus is upon, as it says in Section 3.1a, the words upon which the action is founded, Now, they're not the words taken by the claimant out of a long publication. They're the words taken in the full publication complained of. The claimant can't just take 5 words out of context. One must look to the context of the other words in the publication. And section 3.1b says if the said words are calculated to cause pecuniary damage to the plaintiff in respect of any office, profession, calling, trade or business held or carried on by him at the time of publication. So this brings in an extra hurdle by bringing in the fact that the words must be calculated to cause damage in an office, profession, calling, trade or business. And whilst technically section 3.1b could apply to oral or written communications, in actual fact, in all practicality, because it doesn't say you have to prove the case was written down, the words were written, this will apply to oral communications. And you'll see there at the end it says the test is carried out at the time of the publication. Now, we say these conditions apply at the time of calculation, at time of publication. And what one must do is also look to the other elements of the tort, if we refer to it as the statutory tort. And that is that at the time of publication, the words complained of must be false. And at the time of publication, the state of the defendant's mind must be such that it constitutes malice. And we say that at the forefront of this type of malicious falsehood and related torts, if you were looking to the gist of the claim, one of the gist, or the gist of the claim, it's malice. And in this case, there's been a finding that the words were spoken in the knowledge that they were false. Now, they are my brief observations or interpretation of section 3.1. We say it's obvious what it means, but we do want to look at the rationale for section 3.1. So the court...
So it's obvious what it means. Surely the question is, it says it shall not be necessary to allege or prove special damage. It doesn't spell out what it is necessary to prove.
Likelihood of pecuniary damages. Pure likelihood. The words are calculated to cause pecuniary damage to the plaintiff. And that, of course, is very different to the situation with the common law tort, where the other two ingredients of malice and falsity are the same. But the common law tort demands a claimant prove special damages. So section 3.1 is trying to achieve something different. And the authority or the persuasive authority I rely on, or the wisdom I rely on, if I may go back to the Porter Committee's report, which led to the introduction of this section, and the parliamentary debate. Before I do so, if I could just pray and aid one authority, which is the most recent authority from the Supreme Court on the task that faces you of statutory analysis, and that's at bundle 34 of authorities bundle 2. And you'll see it's Queen and the Secretary of State for the Home Department. And I'm just going to rely on the head note, which I hope is uncontroversial. It's over the page, it's page 740 of the bundle. you see there at F, it begins per incuriam. Statutory interpretation involves an objective assessment of the meaning which a reasonable legislature as a body would be seeking to convey in using the statutory words which are being considered. Words and passages in a statute derive their meaning from their context. A phrase or passage must be read in the context of the sections as a whole and in the wider context of a relevant group of sections. Other provisions in the statute and the statute as a whole may provide the relevant context. They are the words which Parliament has chosen to enact as an expression of the purpose of the legislation, and therefore the primary source by which meaning is ascertained. External aids to interpretation therefore must play a secondary role. Explanatory notes prepared under the authority of Parliament may cast the light on the meaning of particular statutory provisions. Other sources such as Law Commission reports, reports of the Royal Commission and advisory committees and government white papers, I rely on this following part, may disclose the background to statute and assist the court to identify not only the mischief which it addresses, but also the purpose of the legislation, therefore assisting a purposive interpretation of a particular statutory provision. The context disclosed by such materials is relevant to assist the court to ascertain the meaning of the statute, whether or not there is ambiguity and uncertainty, and indeed may reveal ambiguity or uncertainty. Now, moving swiftly on to the report of what was known at the time as the Porter Committee, which suggested this statutory innovation, which ultimately became Section 3 of the 1953 Act. You'll find the Porter report at tab 40 of the Second Authorities bundle.
Yes, I can't help
And it's
merely as a curiosity pointing out that one of the members of the committee was E.M. Forster.
Sorry, was it the
Yes, Forster.
E.M. Forster.
Oh, really? I hadn't noticed that. It's well, it's certainly
other than an oddity. It must
yes.
be him, I think.
Yes. Well, I suppose as a writer, he had an interest.
Yes, no,
in what was being considered.
Anyway, that's by the by.
But if I could just take you to just one paragraph, paragraph 51, at page 824 of the bundle. And what this is doing is identify the problems that have arisen in bringing malicious falsehood claims because of the difficulty there is in proving special damages. And you'll see there at paragraph 51, it says the necessity of furnishing proof of special damage has rendered this type of action rare in the extreme. But statements of these kinds may cause very serious damage, which, owing to technical rules of evidence, is impossible to prove strictly as special damage. In the result, the injured person is left without any remedy for the loss which he has suffered. In our view, this constitutes an injustice which should be righted by an amendment to the existing law. Now, if I could then move
on, what are the technical rules of evidence?
The technical rules of evidence of proving special damages are that one must prove as a direct result of publication there has been an adverse commercial effect upon the claimant. Therefore, one must prove as a matter of fact the words, publication of the words, led directly to a financial detriment.
Well, suppose someone said this product made by the plaintiff, as it then would have been, is rubbish and doesn't do any good. And it could be proved that in the year following publication, sales of the product dropped from, let us say, 1 million to 500,000. Would that fall foul of technical rules of evidence?
It depends on the evidential analysis. First of all, can I just change the example? Because just saying someone's goods are rubbish wouldn't be actionable. That's mere path. But if we start with a statement to the effect,
that was my shorthand.
Yes, that the toothpaste is likely, in fact, to give you tooth decay, and we've proven
Fine.
that scientifically.
Yeah. Right.
And then there's a drop-off in sales. The court would be entitled to infer and analyse the evidence to see, in fact, that had occurred. And it would have to look at all the evidence and exclude other factors, such as perhaps there were other reasons to doubt the effectiveness of the product.
Or that there had been a new rival that appeared on the market at much the same time.
Yes, or there'd been a general downturn in the market.
Yeah, but would that mean that you couldn't prove special damage?
If you couldn't point to the pounds, shillings and pence you'd lost as a direct cause of publication, you would not be able to prove special damage.
That was the law about proof of special damage in 1938, was it?
Yes.
Right.
There is a grey area where the court might accept there had been a general downturn of business, but accept a claimant couldn't prove it. I'm going to come to a case which deals with that, a Privy Council case. But generally, once you reach that stage where the court's scratching its head and saying, well, something must have happened here, you might be able to up the award of general damages.
Well, that's really the point, isn't it? I mean, the example we've given, a court would never, in a different context, a court would never refuse to give damages on the basis that it's complicated and there are other factors involved.
No, it's got to
do its best.
Yes.
On the best evidence available, and it would award what, if you want to put a label on it, you call general damages. But it would still be damages for the same thing.
Yes.
The proof, you use the phrase general damages to indicate that you're not attempting a precise calculation.
Yes, you move outside the realm of special damages.
Yes, so that's the distinction between special damage and general damage in this context. It's a rather different distinction in other contexts. Personal injuries, for example.
Yes.
Well, maybe it is or maybe it isn't.
Yes. Well, I'm going to come to McGregor on damages during my submissions, which deals with this type of tort. Yes. I think that's... I would
anyway, I'm sorry. It's my fault. I don't want to slow you down. I just wanted to be clear what they were referring to by technical rules of evidence. Yes. So this wasn't some special fancy rules or in defamation law. They were simply referring to the fact that it was understood that the requirement to prove special damage meant that you had to be able to precisely quantify.
Yes, yes. And the key point, the common law, malicious falsehood, you have to prove that in order to establish liability.
Quite.
So you can't just hope you're going to rely on something in support of a case of general damages. If you get to that stage, you're shut out at the liability stage. And just finally, while we're on the meaning of Section 3.1, it's curious that the Parliament said you don't have to prove special damages. You only have to prove likelihood of pecuniary damages. And we say that's another indicator of the relaxation that Parliament was introducing here. Because if you take special damages, the gist of it is always there's going to be a net loss to a claimant in order for the claim to accrue. Pecuniary damages is a more wider term, just a likelihood of pecuniary damages, we say is different from a likelihood of special damages.
So when in paragraph 51, they talk about in the second and third line, statements of these kinds may cause very serious damage, which owing to technical rules of evidence, it's impossible to prove strictly as special damage. The very serious damage that's being referred to there is what? Pecuniary loss, which you just can't pin directly.
Well, what I'm hoping to do is on the facts of this case concerning Fiona George, demonstrate, because it's a useful tool in interpreting a statute like this, looking at a real life example, to demonstrate the real adverse effects upon her, which...
Because what it goes on to say is, in the result, the injured person is left without any remedy for the loss which he has suffered.
Yes.
And one reading of this is that what they are railing against is technical rules of evidence. There's a sort of, the word technical is an interesting one.
It's a bit of a politician's word for something legal, I think.
It is, but
yes.
But at least on one reading, it's not a suggestion that you should be entitled to bring a claim without having suffered any loss, or in circumstances where it's known that you have not suffered loss?
Well, Section 3.1 doesn't say that. And Section 3.1 ultimately is the touchstone of this appeal. And I think what you're driving at will come up in the court's consideration for cases like this under the heading, is the tort a really substantial claim? If I could stay with my explanation, because these questions will be answered. If they're not, I certainly expect to be upbraided and reminded of my promise. Now, could I just take you to Hansard, which I've quoted in our skeleton argument at paragraph 11.
Is this admissible?
It's admissible. It's for you to put what weight you want to put on it. But
Normally,
certainly,
it would only be admissible if there was ambiguity and we needed to look at a parliamentary statement to resolve it.
certainly. But if you look at the extract from the recent Supreme Court judgment, it may clear you can look at this sort of material.
Well, if you say so, I wouldn't have said that from the head note. If that were right, it would basically be saying...
my fallback position is I adopt what's said in this parliamentary debate, because we do say it does represent a degree of wisdom which is relevant on this appeal and relevant to the application of Section 3.1. And really, it's the underlined page lines on
Okay, well, we'll look at it, yes, yeah.
Would you like me to read that out, or just?
Sorry, I was just making a note. Which bit of it are we going to?
It's quoted at paragraph 11 of the skeleton argument.
All right, I wouldn't mind actually looking at it in the debate itself, because I marked it up earlier.
It's 41, isn't it? Tab 41.
Yes. Where do you want us to start?
Yeah, sure. If you want to, bear in mind, it's Lever is moving the bill. It's his bill. Yeah. There. You can start from there.
Sorry, I didn't mean to make difficulties.
It's quite right. It's the left-hand column on page 829.
Yes.
828.
828. 828. And it starts in the right-hand column. You can see what was then the draft of Section 3.1, which did change, but not fundamentally. And beneath that, you can see Mr. Lever, who's the MP who moved the bill. And it really follows from there. He says, you see at the bottom of the first paragraph, so the new clause follows on from the recommendations of the Porter Committee, as it be found in paragraph 50 and onwards. And then he sets out the present position is there are a number of falsehoods which are not defamatory on people, which cause them damage in various ways, and which at the present time are actionable only if the injured party can prove special damage. That is actual and direct pecuniary loss. These actions are known as actions on the case for slander of title and slander of goods at the present time. And very often it's very hard indeed to prove special damage resulting from these falsehoods. I may give an illustration to the committee. At the present time, one might say of a man that he is contemplating closing down his business. Unless he could prove actual cash loss as a result, he could not maintain an action.
Just pausing there, it's all a bit woolly, isn't it, about actual cash loss and actual and direct pecuniary loss. I would have thought if you say someone he's closing down his business, and as a result, a number of people withdraw their orders, it would be very likely you could prove actual cash loss.
Well, it's one of those, whenever one's dealing with causation, damage which requires causation, all sorts of impediments can be put in a claimant's way, such as those we were discussing in terms of the toothpaste example.
But I suppose in my Lord's example, I mean, if you could actually show that somebody withdrew his order, then that would be straightforward.
Yes.
The difficulty is that if there isn't any other orders, by definition, you don't know who they would have come from because they didn't come.
Yes, and this is
fair enough. I'm just exploring.
And if I may say, that goes to the nub of it. And again, I'm going to come to McGregor on damages, which talks of this tort being a very example of that type of tort. Defamation is another one, where it stops people dealing with you, and you don't necessarily know who might have dealt with you, who hadn't dealt with you before, or why they stopped dealing.
The difficulties might not be over-exaggerated. I mean, if you're ticking on quite happily and the statement is made, and then suddenly the business drops by 50%, unless somebody says, yes, but there were other factors, the court would hear the evidence, form a view as to whether the 50% drop was due to the statement.
And what it also does, if you have to rely on proving special...
It doesn't mean you can't claim that.
Well, you can claim it, but under common law you need to prove it.
Well,
and one of the other problems is that you can't nip it in the bud. Under the common law provision, you'd have to wait for special damages to accrue before you had a cause of action. Under the statutory provision, you can set out immediately to nip it in the bud, obtain an injunction and damages, actually perhaps even stop you getting to the position where there might be special damages. Just continuing.
This is maybe a point in speculation, in which case don't feel obliged to follow it. But would you have a fresh cause of action, suppose every time one customer withdrew their orders?
The point I would make is there's a 1 year limitation period.
There was in 1938, was there?
In 1938 it would have been different. The 1 year limitation period was introduced in the 1996 Defamation Act.
That's probably irrelevant then for construing. But I'm just interested in your point about if special damage, your point essentially, I understood your duration, is if special damage is at common law necessary to the action, which it clearly is, necessary to the cause of action, you've got to wait till it has accrued. It's not just a wait about difficulty of proof. Your action would actually be premature. However likely it was that people would start to withdraw their orders, you'd have to wait till somebody had, assuming it was a sufficiently clear case, you might be able to plead that as special damage. And what if somebody, but then would you have a fresh cause of action every time somebody somebody else did?
Well, I think
might you have to start you have to have a fresh writ at each point?
This is a case which I'll speak to my learned junior about this, but a cause of action in malicious falsehood, I think the general consensus would be it accrues at the point of publication.
But only
that may not be something not...
Well, that can't...
If special damage is an essential ingredient of the tort, then time wouldn't start to run until special damage is...
So I was talking about the position, as my lord is, at common law. You would say the effect of Section 3 is because the requirement to have suffered special damage has gone, then your cause of action accrues at the moment of publication. But that was not the position at common law. It can't have been if special damage was the gist of the action.
At common law, special damages are the gist of the action.
Exactly. So you couldn't, the cause of action would not accrue at the point of publication.
No, pardon me. My Lord Justice Warby is correct on that. But my argument about not being able to nip it in the bud does still apply.
Okay.
It's curious that, isn't it? Because normally, in other contexts, you would be able to get an injunction to prevent a publication which would be malicious and would give rise to a cause of action. You'd get a quia timid injunction. But you say that the House of Lords has said you can't do that in malicious falsehood.
Yes, well, in fact,
That's why Cannell
it's
is,
the starting
Yeah.
point is perhaps one of the reasons why the Porter Committee looked into this. I'm not going to go through the details, but there's an authority in your bundles, Bundle 1, Tab 2. It's a House of Lords authority in which the House of Lords held that a claimant in common law malicious falsehood was not entitled to an injunction at all because of the absence of proven special damage. Which might seem bizarre, but that was certainly the law up until 1952 when this act was passed.
But they don't actually refer to that as one of the advantages.
I don't believe
That's
they
Lord
do.
Herschel. Well, there you are. How interesting. Well, I think you're probably wise to go down that route. But
Although curiously, neither the Porter Committee nor the extract from Parliament mentioned this
No,
point,
no.
which is a fairly large benefit to claimants, if you're right.
That you can nip it in the bud.
Yeah.
Yes. And it's a real and proper remedy for stopping someone acting in a malicious and false way by telling falsehoods about you, which are likely, you don't have to, which are likely to hit you in the pocket.
So you think they sort of accidentally changed the law in that respect without really appreciating what they were doing? Or why didn't they mention it? Why didn't, I mean, there's plenty of discussions here about damage, but nothing at all about injunctions.
That's a rationalisation that I introduced. But we do say it's a proper reason for finding that Section 3.1, if it works in the wording of the statute, does achieve that end, and that's a proper end to be achieved. And we say, and I'll come to Mr.
I'm not
Price's
suggesting it's
submission.
an improper end.
No.
My only point was that if you're right, it's a proper end which the committee and Parliament plainly overlooked or didn't have in there.
Yes, it's not something they deal with. But then the quotation from Hansard continues, bottom right-hand corner, page 828. We could say of a member of Parliament that he was contemplating not standing at the next election and say that falsely and maliciously. And then Mr. Silverman interrupts, said that, well, that would not be defamatory. And the answer which I make to that is precisely because defamation doesn't stop of itself all types of harms being caused to claimants.
yeah, but that's
by
a red herring.
publication of
That's
false-
just a sort of silly interruption.
Yes.
But, going on with the point that the promoter of the bill was making, it would be damaging, but the difficulty would be in proving actual damage, and it's precisely because such statements are highly damaging it's necessary to bring the law up to date. Obviously, we've only got the words here. I'm puzzled by that example. What damage, what recoverable damage would the MP be likely to suffer
At the point of publication,
at the point of publication from that
the
statement?
likely damage would be his lost salary as an MP.
Well, he wouldn't lose his salary, it just says he's not going to stand at the next election. He was contemplating not standing at the next election. He's not being removed now.
It's a very odd
Well,
example.
I think the point about that is then he in fact does stand for election, and that his electors, or some of his electors who are loyal to him, they vote for him rather than his party, don't vote for him.
But then they know.
He is standing.
Then they know he is standing.
Let me just.
It's a
We
very
could
odd
say a
example.
member of Parliament.
It's a really odd example here because he's serving as a member of Parliament. 2 years into the term of Parliament, they say he's contemplating not standing at the next election.
Yeah.
He doesn't suffer any immediate loss at all because he carries on being the MP. And when the next election comes round, lo and behold, he does stand.
Yes, but then his personal supporters don't even turn up at the ballot box.
Well, why
to vote
not? They
for
know
him.
he's standing.
Well, you can't assume that
Well,
because they've been told.
well, they were told 3 years ago that he was then contemplating not standing, but he's been out canvassing with it. He's on the ballot paper.
Well,
it's necessary.
He's mitigated.
Yeah.
But one can see, maybe that's not the best example Mr. Lever gave.
I don't think we're going to get much out of this example. It's a very odd example. Why I'm interested in it, though, is assume that the result is that he does not get elected. I think the unspoken assumption is that the result of this statement is that he is eventually not elected when he might otherwise have been.
Yes, obviously it's been
let's assume that's what Mr. Lever had in mind. The loss he would suffer would be the loss of his salary as an MP.
Yes. The likelihood of that loss.
I see. So it is looking at pecuniary loss.
Yes. Potential pecuniary loss. And then once you've proven liability, you prove damage, which I'm going to deal with at some length.
I mean, the previous example of the man contemplating closing down his business is a much more understandable one.
Yes.
That leads to immediate loss of revenue.
Yes.
Because people think, well, if he's going to close down his business, I'm not going to send my order there. I'll send it with another business.
And then you run into the special damages.
It may
point.
be that maybe Mr. Lever was just pandering to the fact he was talking to a bunch of politicians and tried to give them an example of a little closer to home.
I think so. It may have been designed to catch their attention.
Because
go on support.
To say it would be damaging, I just find it difficult to understand in what possible sense it could be said to be highly damaging. The statements are highly damaging.
But just to finish with the quotation, it would be damaging, but the difficulty would be improving actual damages, precisely because such statements are highly damaging. It's necessary to bring the law up to date. I would say, in view of the comments widely made that this is a defendant's bill, that this clause will provide very real protection and benefit to aggrieved persons who suffer damage as a result of malicious falsehoods. It will provide a real benefit which does not exist at the present time. One great authority on the law said, we have great hinterland of the law of damages where the king's writ does not run. And this clause, we are seeking to send a party into that hinterland in order to establish a certain amount of ethical and moral principles. And you'll see just further down, just to finish this last quote in the skeleton, I believe it will give a substantial additional protection to people who are likely to suffer from malicious falsehood. So we see there that Parliament is trying to...
Isn't the one you skipped over rather important to your case? The effect of this clause will be that wherever a false and malicious statement is made, which naturally be calculated is published in a permanent form, he would have an automatic remedy.
Precisely.
And be able to maintain his action on the case.
Parliament is saying where a false statement is made with malice, which is likely to cause pecuniary damage, there will be an automatic remedy. Now, the only qualification to that, which has come to pass since 1952, is the Cannell jurisdiction to strike out a claim that isn't a real and substantial claim. And we say on our analysis of how this tort works, that will stop claims which are frivolous. But putting that to one side, Parliament has stated...
When you say frivolous, define frivolous. Because by definition you've got a statement which is false and malicious.
Yes.
Why is it frivolous?
Well, frivolous is perhaps the wrong word. I'll stick with the words of Cannell, real and substantial.
So real and substantial for Cannell was borrowed from another context. What it really means is that in the circumstances of the case, the pursuit of the particular cause of action cannot be justified as a lawful interference with freedom of speech.
Yes.
Because there's no point to it.
Yes.
There's a real point.
If I can give an example, for instance, if it were said of an accountant, he's a terrible teacher, he always turns up late for lessons, then clearly, technically, and that was in writing, would satisfy section 3.1, but the court would use the Cannell jurisdiction to strike out such a claim.
Why would it satisfy 3.1?
Because section 3.1 says The words upon which it actually found are calculated to cause pecuniary damage.
But why would it be calculated to cause pecuniary damage to an
or,
accountant to say that they are a terrible teacher?
Well, it's maybe that was a bad example. It's Jamil. What I would say, I'm going to deal with this on the facts of this case because Mr. Price has raised it in his skeleton argument. Just does stop claims which you might think are technical claims, which really have no real purpose from proceeding. If you call that's the safety net when you're considering this type of claim.
But again, you have to define purpose and technical. Are you saying that a claim which would only sound in nominal damages should be struck out because it's...
No.
Because so define the claim that's, well, you started off with frivolous and now it's technical or no real purpose. Can we define this claim that you're trying to identify?
Well, it's not the claim mounted by Fiona George, I'd say that.
No, I think we...
It's if I may return to that point, perhaps give a better example than the one I gave just now. But the circumstances are almost infinite in which you might reach that conclusion. And really the point I'm making is there may be a set of facts in the future where the court would conclude that Section 3.1 was satisfied, but the Jamil test wasn't, and for that reason strike out a claim brought on the Section 3.1 basis.
Just so I understand, you're going to be telling us that a claim which could only sound in nominal damages would not fail the Jamil test.
Well, what I'm anxious to do is deal with the facts of this case. The facts of other cases are infinite. What we would say, and I will say shortly, is if you establish a case on Section 3.1 and you've established someone has deliberately set out at the point of publication to allege a falsehood against you, which is likely to cause you pecuniary damage, then you deserve a remedy. And however difficult it is for the court to calculate the damages for such a remedy, for that publication, you should have the remedy of damages. And the court, as has always said, will have to do the best it can. Once you've passed that hurdle, we say that's will nearly almost be always satisfy the Jamil test because it's such a serious thing of itself. Then you can pray and aid damages for distress, including damages for the way a trial has been conducted, and you also pray and aid other damages. Now, I'll come to it shortly, but this is very much a case in point, because what happened at the point of publication was that Fiona George was told not to contact clients who it just so happened the second defendant had been dealing with, and led to a series of events by which within 7 days of publication, Fiona George had resigned from her employment. Now, it so happened she got a new job with a higher salary, but she had to leave and join a different sector. Now, I say those damages are very much real and substantial. And once you've satisfied Section 3...
Well, hang on, what's real and substantial about them? You've just accepted that you suffered no pecuniary loss. So what's the real and substantial? Is it the distress of having...
I'm not... Pecuniary damages, she mounted a claim on special damages, which has not succeeded. She mounts a claim on the issue of liability in regard to malice, falsehood, and likelihood of pecuniary damage. Once she satisfies that, the court's got to look at the issue of quantum. And so we say quantum really falls into...
Quantum is a bad word. Quantum just means how much. But the more important question is for what?
Well, for what? Very well. For what? Firstly, the publication itself. Publication of malice, which is likely to cause damage. In order for Section 3.1...
Hang on 1 second, just to write this down. So I'm putting down what her claim for damages is for.
Now that's...
For what loss? And your first one is, one, publication itself.
Yes.
But then what does that mean?
Well, can I break it down for you?
Okay.
seriousness of the allegation, the quality of the publishees. So, for instance, this case.
No, sorry, I'll ask you. I'm not making my question sufficiently clear. Publication itself means nothing unless it causes her loss. So, what loss is caused by the publication?
Yes,
I thought your answer was going to be, well, one answer might be damage to her reputation. Problem about that is, that's the one thing we all agree, malicious falsehood doesn't protect you against. Second kind of answer might be distress.
Can I stay with my three components?
All right, okay.
I promised you.
All right,
I'm going to do my best.
One is publication itself.
Publication itself.
Yes.
You've got to look at the seriousness of the lie.
Is this a subhead of publication itself?
Well, this is a damage arising immediately from publication, is one way of looking at it.
Yeah, it's under your first head, publication itself.
Yes,
You're just
publication
the first
itself.
head.
The seriousness of the allegation, some allegations would be more serious than others. The quality of the publishees. So, for instance, Fiona George, it was sent to her direct line manager. So that's a serious factor. The quantity of publishees. The fact of malice itself, well, that is a component of the wrongdoing. It's not just something that it's thrown in later on. It's part of section 3.1. So the fact of malice itself and the degree of malice. And on the facts of this case, the judge found that there was a degree of premeditation in this claim.
This all sounds like punitive.
No, it's not punitive. It's not
punitive. Why should it be relevant that it's premeditated? That makes it morally much worse, but this isn't about moral...
Malice is morally bad. And Parliament has brought in a statute to compensate people who are victims of malicious allegations.
You've got to be careful what you say. The point my lawyer is making, I think, is when you say compensate, you're suggesting that they've suffered a loss. Whereas I think the point my lawyer is putting to you is that this is to punish the wrongdoer, irrespective of anything else. So all the factors you've listed, you haven't once mentioned the person themselves, the subject of the lie. It's how many people was it published to?
Yes.
Who were they? How bad was it? How serious was the lie? It's all to do with punishment.
It's upon the
publication. It's got nothing to do with, at the moment, this first head. Nothing to do with anything to do with the person who was the subject of the lie.
I'll come to McGregor on damages shortly. Yeah. But the point is, Parliament's held the claimant ought to be compensated for this act. And it's one of those cases where in order to give this tort teeth, a court has to award damages and do its best it can to award.
I think this is all very heterodox to me.
Can I state...
All right, okay. Well, I'll let you finish your 3 points, but then I really do need to understand what you're saying. So your first point is publication itself, and you've made all these sub-points under publication itself. I think you said
they're part of publication.
Sorry?
They're part of the publication.
All right, okay.
They're part
Fine, I got that.
Second component, distress.
So and just pause before we now we are moving on to distress to the person who is the subject of the lie. So just before you go to the distress, because that is identifiable as...
Yes.
In the parliamentary debates that we had open, and they still have open, there's this little bit at the end of the second full paragraph on page 935, where one great authority on the law has said we have here a great hinterland of the law of damages where the king's writ does not run, and by this clause we are seeking to send a party into that hinterland in order to establish a certain amount of ethical and moral principles. I'm afraid I just don't get the reference to the king's writ not running and sending a party into the hinterland and the great hinterland. You may have to explain it to me, but is what you've just been saying that it is part of this section, this clause, to introduce a bit of ethical and moral principle by punishing the publication itself?
It's,
Or am I reading far too much into it?
if I were to paraphrase it in the word of perhaps another MP in the debate, it's basically saying people shouldn't get away with this. But that debate does talk about real harm being caused by such publications.
I think where we was intervening a few moments ago is trying to identify your first head, which seems to have nothing to do with harm to the claimant of any description. I use the word harm in its broadest sense. It's all to do with purely and simply introducing some ethical and moral principles to stop people telling lies.
Well, if Section 3.1's to work, then Section 3.1 must necessitate the payment of damages where it's breached. And we say by publication itself, and the factors concerning publication, the allegations made, the degree of malice, who it's published to, the quality of the people it's published to, will be relevant. My second two components are closer to home and can't be objected to on the basis that this sounds artificial. And the second component is distress caused to a claimant. Yeah. And I'll come to the evidence, the uncontested evidence and the findings of the judge shortly.
What's the third head?
The third one is other post-publication factors. So you'll see on the evidence of this case, there was serious disruption to the claimant's working life.
What? That's irrelevant unless it causes her distress, isn't it? How's that different from distress?
Well, it's one of those things that the court has to grapple with. I realise you would say, well, that's not much of an answer. But in a court, order for this talk to have effect, the court's got to look generally at what happened to the claimant after the publication. And the evidence on distress isn't contested. We say it's credible if one looks at the facts of this case. But there's a real disruption to her ability to work. She's immediately told by her employer not to contact clients who happen to have dealt with the second defendant previously. She has to take a day off work, and I realise distress is tied in with that. And for reasons set out in her witness statement, which I'll come to, she decides not only she can't stay in that employment, but she needs to work for a different industry.
Well, I've let you more or less make your 3 points, but this is how it seems to me at the moment, in case you want to come back to me. Conventionally, in any tort, what you are, damages are compensatory, they are not punitive. We can ignore special cases like exemplary damages. So you have to ask, what are you compensating for? In this case, it seems to be accepted there is no pecuniary loss to be compensated for. There's no personal injury. And we're really therefore left with only one thing that's been compensated for, which is distress, or you can call it injury to feelings, but it's the same thing. Now, I'm not saying there's anything wrong with that, but at the moment, that seems to me to be the only head of damage or head of loss for which your client, if you've succeeded on liability, will then be entitled to compensation. No, not a problem. Someone will have to assess it. You're not asking us to.
No.
But I just want to understand what the nature of your case has to be about the nature of the law. Am I not right?
Can I apply one different analysis for reasoning on this? Section 3.1 applies to corporate claimants, to non-living claimants, as much as it applies to living claimants. Clearly, a non-human cannot experience distress, but it was clearly the intention of Parliament that such an entity should have a cause of action
Well, they would have a cause of action, but all they get would not be nominal damages. They couldn't prove pecuniary loss. I mean, the dead player, I hadn't noticed about non-living claimants, but I assume you're right about that. Their estate could claim for pecuniary loss if there had been any. A company could claim for pecuniary loss. But in a case like this where there isn't pecuniary loss, saying that, well, that means companies wouldn't get anything because companies can't suffer distress, goes nowhere, doesn't it? Okay, they wouldn't get anything, so what? They just get nominal damages.
But there still has to be an ability to bring a claim like that.
Yeah, fine. Fine.
I
don't think any of this is particularly damaging to the main point you were making,
Yes.
which is liability. But the point that we had got onto, not I think led by me, I think you got onto it yourself, was what kind of loss they could recover.
Yes.
And at the moment, and can't speak for my lords, the only loss on the facts of this case that she could recover over and above nominal damages is damages for distress. Am I not right about that?
Well, that's not my case.
But what is your case?
My case is one is compensated for the publication of a false statement likely to cause pecuniary damage, and that will be different in different scenarios. Where there is.
Sorry, I'm going to just interrupt if I may, because I think you've used that word compensate again, which I think is the one that set the bench
Yes,
because compensate to most people connotes some loss which you're aiming to remedy.
Yes.
And what I think your case is, as I understand it, is that damages can be awarded, or a monetary award can be made. Let me make it as neutral as I possibly can. The court can order the defendant to pay a sum of money to a claimant.
Yes.
Purely because the claimant made a false, malicious statement. Even if there is no financial loss caused, even if the even if the claimant may never have actually learnt of it, even if it's a corporate claimant which has no feelings to be injured.
Yes.
It's your case, I think, is
It is.
the pure publication of a false
Yes.
and malicious statement calculated to cause loss.
And that's the first element of damages.
Will result in a monetary award, which the
Yes.
court will just have to put its finger in the air
Yes.
and measure and come up with a number. And I think that's what your case
Yes.
is.
Yes,
I'm
I
going to
thought
come
that
to
was what you were trying to
McGregor,
get to. But you can't talk about compensation in that field. I can't think of any other area, with the possible exception, or Justice Warby will know much more about this than me, than defamation, where you can get damages which are not regarded as punitive, but nor are they linked to distress for the mere doing of the wrongful act. My very limited reading of the nature of damages for defamation is that there is what's described as consolation or solatium for the injury to your reputation. And that in principle is separate from, it must overlap with a good deal, any distress you may feel about the injury to your reputation. But that is surely a peculiarity of the law of defamation, because it's about how you compensate for injury to reputation. But we're not in defamation in this context, are we?
No, we're not.
But you're saying that something like that principle should apply equally here.
Yes, I keep referring to McGregor, so I think it's good that I jump to it.
I'm going to jump in just once before
Of course.
we do that.
Yes.
And that is that there is one other area, leaving aside solatium, which may have been overtaken by subsequent law, in which individuals, anyway, can recover compensation for something that isn't easily recognisable as a traditional head of loss, which is in invasion or intrusion into privacy.
Yes.
Where apparently one can recover damages for the mere fact of the wrong, because it's an interference with your convention rights.
Yes.
And as I've understood the submissions you've been making, some of them seem to head into that general area.
Yes.
In the case of an individual,
Yes.
can't think how they could apply to a corporate claimant, but I may be not thinking hard enough about it. But at any rate, all of that seems to me to be, on your submissions, material that would have to be considered by a judge if you succeed on liability,
Yes.
and we do what you ask us to do, which is to remit the case for an assessment of damages.
Yes.
Your point is that satisfying Section 3 on liability is enough to recover a monetary award, and just because it may be nominal, it wouldn't necessarily be a Jameel abuse.
Yes.
Well, thank you. That's been very helpful to me. It took a bit of time to get there. It's probably my fault, but it does bring up this point. I don't really think these points which we've been exploring in the last 10 minutes, 20 minutes, whatever it is, directly arise on the Snowden arguments. Maybe they've got into them at one or 2 points. And yet it might be thought rather unsatisfactory that the matter should go back to the judge with no guidance in an area where clearly there isn't much clear law.
Yes.
With no guidance from us about the exercise we expect him or her to do on the assessment of damages. Are you inviting us to give guidance on the heads of loss that would be available, not on the factual application, but the heads of loss that would be available? Or are you saying, well, none of this really arises, it wasn't argued below, we'll just have to leave it all to the judge, and if necessary, there'll be a further appeal?
Well,
not a very attractive.
The main reason why I've raised these points is a defensive reason, and that's Mr. Price, on behalf of the defendants, is asserting this isn't a real and substantial tort on the facts, and for that reason shouldn't proceed. He's also asserting this case is just about the costs and nothing else.
Well,
what I'm trying to do is look at the substance of the claim. And I hope you have to outline some of the facts and use McGregor, because what the court is grappling with today is the same type of reasoning it had to deal with in the case of Gulati, the Court of Appeal case in Gulati. I'm afraid it's not in the bundle. It's the case my Lord Justice Warby alluded to, where the court had to look at damages for publication of private or misuse of private information. It was very easy to look at the distress caused by that, but the court concluded that it was one of those cases in which there would be damages payable merely for the misuse of the private information. And that's perhaps where the reference to Solatium comes in.
I mean, there is a distinction between cases of invasion of privacy, the breach of your right to privacy.
Yes.
I mean, in a sense, by definition, you have a right to privacy which you should be entitled to enjoy, and if it is taken away from you or the right is infringed, in a sense, the judge can compensate you for the fact that your right to privacy has been infringed, that your private papers have been published, or whatever. In a sense, it is a form of compensation for damage to a right. But your first head is not based upon damage to a right of the claimant at all. It has nothing to do with the claimant. It is purely and simply ordering somebody who has behaved badly to pay a sum of money as a consequence. I mean, that's really what your first head boils down to.
Yes, the word...
Where does a judge sort of get off on that? I mean, how does the judge sort of pick a number?
Could I just stay with the use of the word right? Clearly there isn't a right as such here, but there is what one might call a right enacted in section 3.1, whereby a claimant should not be subjected to that type of behaviour.
Everybody sort of, in a sense, like you can see why everybody would agree with that as a statement.
Yes.
But in terms of the basis for an order of payment to pay a sum of money, your first heading, publication itself, divorces that award from the claimant, other than the
Well,
fact he's the
I'm
person
not-
you say entitled to bring it under standards.
I'm not saying the court ought to give a judgment where it breaks down the three components. I think the court awarding damages will probably make one award of general damages, perhaps a second one
True,
for
but
aggravated damages.
But you could think of it's not very difficult to think of a situation where, let us say, somebody is made the subject of a false and malicious statement about their professional abilities. But before they learn about it, the very next day, they are knocked over by a bus and are in a coma and remain so. They never have hurt feelings. Their professional practice would have suffered in any event. There's plainly no compensatable damage, injury to feelings, or anything else. But you'd say, I think, that a representative of that person lying in the hospital can nevertheless bring an action which could not be struck out and would result in a monetary award.
Well, on those facts, it probably would be struck out.
Well, why?
Under the Cannell jurisdiction.
Why?
Because it's not a real and substantial tort.
Well, it is.
For the reasons you've outlined.
According to you, it is a real and substantial tort because it's the publication of a really serious and malicious falsehood about the person. And that is of itself, you say, actionable.
Yes.
So
but
how
the
can
courts,
Jamil strike it out?
But the court's got a general jurisdiction to look at that and say, well, look, it's obvious this is an artificial claim. There's no proper end to it, no proper aim. It should be struck out. That doesn't mean Section 3.1 hasn't been satisfied.
The proper end is I want my judge to put a number on the wickedness of the defendant's conduct, publication itself. That's what I want the judge to do. You're saying that's what the judge has to do. How can it be said that it should be struck out under the Jamil heading rubric?
Because it's a claim that serves no proper purpose, because the claimant, effectively the claimant is dead. One can always find cases like that on the one side of the spectrum of facts, but it's easily dealt with under Jamil. If one sticks with Section 3.1, then that is the task the Parliament's given this court.
I don't know why you're so worried about Jamil. It may or may not be strikeable out in such a case, but the point of principle is that there is a cause of action, and once there's a cause of action, the claimant wins on liability, and the case has to go off to be for an assessment. The result of the assessment may simply be if you do badly, nominal damages. But if you're right about there being another head of damage, whether or not linked to distress, may do better than that.
Yes.
Anyway, there we are.
It's staying with the issue of damages. Of course, if the court chose to give guidance on the issue of damages, it would be probably the first court that did so. It was alluded to in Joyce and Sengupta, another Court of Appeal case. But if I could deal with the issue of McGregor and deal with the facts of this case, I keep saying I'm going to return to those because I think they show a good example of why Section 3.1 of itself needs to be compensated in damages, the breach of it, in order for Section 3.1 to work as Parliament intended. So can I just jump straight to McGregor on damages? You'll find it in Authorities Bundle 2, tab 46.
Yes, you've quoted from chapter 10.
Yes.
Extracted from. Anyway, go on. Yes.
Anyway, very quickly, page 978. I'll refer to the bundle page numbers.
Yes.
Page 978. the first complete paragraph there, beginning on the other hand. Now, it talks about substantial loss. I'll proceed to make that good later on. But effectively, this comes down to saying that where precise evidence is obtainable, the court normally expects a claimant to have it, but where it's not, the court must do the best it can. That's the indented quote at the end there. And that's the task that the first instance judge will find him or herself in when and if quantum is assessed. Just because damages are difficult to assess doesn't mean the court shouldn't
This
assess
is all very obvious stuff, but the real problem is the one we've discussed earlier. What sort of damages are we talking about? This tends to be about financial loss.
Well, can I jump forward to page 981 of the bundle?
Yep.
And you see paragraph 10010. In some cases, general damages may be awarded in the sense of damages, such as the jury may give when the judge cannot point to any measure by which they are to be assessed, except the opinion and judgment of a reasonable man. And then the second paragraph really brings alive the principle that my Lord Justice Snowden referred to. Tort provides most of the illustrations, and the home ground of such cases is to be found in torts which involve interference with the claimant's relationships with other people generally. This would seem to be because damages are particularly difficult to assess where loss is caused by reason of other people refusing to enter into or ceasing from relationships, whether of a business or a social nature with the claimant. The tort of defamation is perhaps the most important example in this respect. Thus, in Tripp and Thomas, where the defendant suffered judgment by default, the claimant gave no evidence and the jury awarded £40. It was held that this award should stand as the jury were not bound in such circumstances to give nominal damages. Now, proceeding over the page, at the top it says, another illustration is found in conspiracy. Thus, in Quinn and Leatham, the following passage appears from the trial judge's notes of the evidence. I told the jury that pecuniary loss directly caused by the conduct of the defendants must be proved in order to establish a cause of action. I advised them to require to be satisfied that such a loss to a substantial amount had been proved by the plaintiff. I declined to tell them if actual and substantial pecuniary loss was proved to have been directly caused to the plaintiff by the wrongful acts of the defendants. They were bound to limit the amount of damages to the precise sum involved. So although that's a pecuniary damages claim, there's something in addition to that.
Well, is that something? No, that's not quite right. Is something in addition to... Well, we don't know the context. We don't even know who the judge... I can't remember who the judge was the first instance in Quinn and Leatham. But surely all he's saying there is you've got to be satisfied they suffered pecuniary loss, but if they can only prove £10, precise sum of £10, but you think they may have suffered more, you can give them £20.
Yes, but turning back to my first complaint,
It's like the distinction we were making earlier between special and general damages.
Yes, but if there's been publication to one person rather than publication to 10,000, you'd expect, putting distress to one side, the damages for acting in that way to be greater when there have been publication to 10,000. The heading further down, page 982, it talks about whether loss is non-pecuniary. And you'll see it says there, even where it is clear that a loss has been incurred without damage being presumed, it cannot be calculated in money with mathematical precision, where it is one of the many non-pecuniary losses for which recovery is given, particularly in tort. There's no good reason for refusing damages altogether. Money in such cases is not awarded as replacement for other money, but as a substitute for that which is generally more important than money. It is the best that the court can do. And we say this is an example of that. The word solatium comes to mind. But in order for this tort to be effective, particularly effective for non-living individuals as claimants, the first component is real and it is live. The only real authority that grapples with the issue that concerns the court at the moment is that of Joyce and Sengupta. Now, just to give you the background of that case.
Just before we leave,
yes.
McGregor, I don't know whether this is likely to be relevant, but you might just care to look over the agenda at the discussion of general and special damages in chapter 3.
Is this in the extract?
This is not in the passage you
me.
extracted. No, so you won't have it to hand. Don't look at it now.
Yes.
But that's why I was drawing it to your attention. I found that helpful. It really just points out that these are slippery terms and they mean different things in different contexts.
Yes.
It's paragraphs 3001 to 3006. Right, sorry, you were going to take us to Joyce and Sengupta.
Joyce and Sengupta. Now, this is a case where the claimant brought claims for malicious falsehood under section 3.1. It's a claim of the sort we're dealing with, a statutory claim for malicious falsehood. There was an attempt to strike it out on the basis that it was an abuse of the process, because really the claim should have been brought as a defamation claim. The Court of Appeal had no truck with that and held there was no abuse of process. Therefore, the malicious falsehood claim could proceed. Now, one of the points made on behalf of the defendants was the claim shouldn't be allowed to proceed because it would be economic lunacy for the claim to continue. And that really led to one of the few significant discussions of damages and malicious falsehood claims that has occurred in any court, and certainly in the Court of Appeal. The relevant paragraphs are quoted at paragraph 30 of my skeleton argument. The authority itself is at tab 6 of bundle 1. And the first, would you rather I refer to my skeleton argument? Or
no, well, I obviously read it and read it in the judgment. So speaking for myself, I'd rather we looked at the report.
Is page 3. What is page of the bundle? 69 of the bundle, bottom right-hand corner. And I'm just going to go from paragraph D to H. This is talking about...
Well, shall we just read it to ourselves?
Oh, please. It's paragraph D to H, if you wouldn't mind.
This is relevant, isn't this bit? If you say so, we'll read it. Let's have a look.
Yes.
So which paragraph? Which page?
Page 69 of the bundle.
Oh, 69, D2. I'm so sorry. I was looking at the wrong page. No wonder I thought it wasn't relevant.
Paragraphs D to H.
Yeah, okay.
Particularly just above H.
Yeah, okay.
And it's really that expression just above H. For present purposes, it's sufficient to note that if a plaintiff establishes the defendant maliciously made a false statement which has caused him financial damage, or in respect which is relieved from proving damage by the Defamation Act 1952, the law gives him a remedy. So it's one of those cases where the court must do the best it can. Parliament held that damages caused by breach of section 3.1 in conjunction with malice and falsity. And the court's got to give a remedy. In terms of whether damage...
the remedy may only be nominal damages.
Well, in terms of that, of course, that's going to depend on the facts. But the Vice-Chancellor made clear in that case at... Sorry, I'm just finding the bundle page reference.
I'm assuming the passage you're going to take us to is at page 75 in the bundle, 347 in the report.
Well, actually, just before that, page 74 of the bundle. The last paragraph there, beginning on this interlocutory appeal. And particularly...
Can you help? Can you elucidate? He says, this is an allegation of general damage. That's referring to how it's pleaded. Yep.
Yes.
In support of this claim, the plaintiff cannot deduce evidence of actual loss, see Culbert and Tompkins.
Yes.
I don't quite understand that, but is it simply saying that if you don't plead actual loss and rely on general damages, you can't turn up to court with evidence of actual loss?
Well, we'd say it goes further than that.
Have we got Culbert and Tompkins in the bundle?
Yes, if you're proving a section 3(1) case, you can't turn up to court and say, well, look, my income went down after publication. That shows at the time of publication damage was likely. One's got to look at the matter at the time of publication. I'm going to come.
I'm sorry, I hadn't looked at Culbert. I see you're right. It is in the bundle.
Yes,
So
it's only 2 or 3 pages long. And Lord Denning's interpretation of section 3(1) is really on all fours with the interpretation being advanced by this side of the court.
Okay, anyway, we can look at that later if we need to. Yeah.
I'm just staying with Joyce and Sengupta.
Yes.
Bundle page 75. Just by paragraph B, where it says the whole purpose of section 3 was to give the plaintiff a remedy and malicious falsehood, despite the difficulty of proving actual loss. The plaintiff is unable to call witnesses to say they ceased to deal with him because of some slander that has come to their ears. And you'll see there it actually also refers to the report of the Porter Committee. My lords.
But I understand entirely that proposition. There's a malicious falsehood uttered or published. It's obvious that it's going to cause some actual loss to the claimant.
Yes.
But the claimant can't pin any particular identifiable loss of a contract or business to that statement.
Yes.
So section 3 steps in.
Yes.
And says you can nevertheless sue because in a sense it's obvious or it's calculated likely.
Yes.
You should have a remedy.
Yes.
But your submission that I've been worrying away like a dog at a bone with is actually, it goes a lot further than that.
On that first component of damage.
Because your contention is that it's publication simpliciter of itself.
Yes.
Which gives rise to the cause of action.
Yes.
And there's nothing about that in this at all.
This being Joyce and Sengupta.
Yeah, I mean, there's not a hint of that. There's not a hint that
well,
publication of itself.
No, the facts don't even get into that. Most of the consideration, in fact, is over to dicta because it's in response to the submission by the Defendants Council that the claim would be economic lunacy. And the court just says the damages could be very, very substantial, but doesn't go down. It's not an appeal on a trial decision. It doesn't go down that route.
Just taking the point you took us
yes.
Just to B, the sentence, the whole purpose of section 3 was to give the plaintiff a remedy in malicious falsehood, despite the difficulty of proving actual loss. I mean, it doesn't say the whole purpose of section 3 was to give the plaintiff a remedy in malicious falsehood, irrespective of whether they've suffered any loss.
Well, it doesn't, and it wasn't charged. The panel then wasn't charged with adjudicating on that. And ultimately, they were reluctant to reach firm conclusions on the issues of damages. But fundamentally, they were saying damages could be substantial. But he didn't deal with this issue that I'm raising about the first component of damages, which arises by reason of the publication of a false statement with malice. But I should say on the issue of distress, of course, the greater number of people it's published to, the more likely it is to cause greater distress. The greater the malice, the more distress, and so on and so forth. Whereas at the first stage, I think you can isolate that first component.
Your second head.
Yes,
I'm not worrying away at it.
Which is quite conventional, frankly.
Well, are you coming to distress later, or should we deal with it now?
Pardon me one second. Could I turn to the facts?
No. I want to stick with Joyce's
Yes.
and Gupta for the moment. I am puzzled by the heading damages for distress and injury to feelings, or turning around puzzled as to what your position on it is.
Could you give me the paragraph reference?
It's not paragraphed.
Oh, right.
It's an old-fashioned judgment, doesn't have paragraphs. There's page 347 in the judgment between D and... It's 347D following.
Yes.
It's really the great meat of what Sir Donald deals with. What he appears to say in those passages that you can only get damages for injury to feelings once pecuniary loss is established.
Yes. Well,
And if you say yes, and that's fine if you accept that. So I'll hear what you say about it. But there are a number of passages where one can see that's pretty explicit. And he also refers to injury to feelings being parasitic on pecuniary loss. So what about the question is, I appreciate it's all obiter, but to the extent that it's authoritative, why is it right that in a case where there is no pecuniary loss, as established here, there should be any injury to feelings? Sorry, damages for injury to feelings.
this is obiter.
Let's assume for the moment that it's nevertheless binding on us.
Yes.
I want the answer to it in its own terms. You can say it's wrong if you like.
If there's a common law claim, you have to prove pecuniary damage to obtain damages for distress. We say if you satisfy section 3.1, the need to prove pecuniary damage falls to one side. Therefore, you can claim injury to feelings. Now, in fact, a later Court of Appeal case, Coda Parast, actually gave a ratio decidendi on this issue.
Yes.
Which I can take you to. That's at tab 8 of the first.
Just pausing here, are you saying, perhaps in a sense, your answer, and maybe I could have paid no attention to this when pushing the point to you, is that at 347D, he says once pecuniary loss is established or a claim under section 3 is made out.
Yes.
So your answer is that actually Sir Donald at least was accepting that you could have damages for injury to feelings in the absence of pecuniary loss, provided it was a section 3 case.
And that we would say is what he's saying. It is logical because section 3.1 it removes the common law requirement for there to be actual financial damage and replaces it.
Yeah, well, that may be it. Speaking for myself.
Is that really though what he's saying? Section 3 applies to claims for malicious falsehood, correct?
Yes.
It's not a separate cause of action, is it? It's not a separate cause of action. As Section 3 says, in a claim for malicious falsehood, etc., etc., etc. So it's not setting itself up as a separate cause of action. And Sir Donald says at 348, just above B, he says quite clearly, although injury to feelings alone will not found a cause of action in malicious falsehood. I mean, that must include even a case in malicious falsehood where Section 3 is pride in age, surely.
Well, I think it's easily solved by going to the case of Code of Paras.
Okay.
It's the authority is at tab 8 of bundle 1 of the authorities.
Yes.
I'm just asking Mr. Busuttil to remind me of the passage I'm looking for.
Is it 30.6,
Okay.
30.6.
And it's paragraph 42. Of that judgment, which is on page 99 of the bundle. It's just at the bottom of the page.
Starts with a rather questionable statement, isn't it?
Paragraph 42, that is.
Yes, malicious falsehood is a species of defamation.
Yes, that's applying a very wide definition to what defamation is, because clearly defamation centres on the issue of reputation. Because malicious
You're being
falsehood is
kind,
something
as you
different.
can't say a court of appeal judge is wrong, but that's wrong, isn't it?
I would say so. The diplomatic responses all depends upon your definition.
Another diplomatic response might be that this section is a section of the Defamation Act 1952.
Yes, of course. It's malicious falsehood tends to get lumped in with defamation whenever Parliament enacts new statutes about both.
Yes, I'm not just being picky and trying to pick a fight with Lord Justice Stuart Smith. It's just that I'm trying to understand all this area. One thing that's become very clear to me is that they're concerned with fundamentally different things. One is
Yes.
concerned with damage to reputation, and one
Yes.
is concerned with other forms of damage
Yes.
caused by malicious falsehood.
Yes.
Anyway,
Malicious
all right,
falsehood.
okay, enough said about
Yes.
that.
It's well established that aggravated damages can be awarded for defamation of character for the additional injury to feelings caused by the defendant's conduct, both before and after the issue of proceedings. In my judgment, once the plaintiff is entitled to sue for malicious falsehood, whether on proof of special damage or by reason.
There must be a missing word there, mustn't there?
Once the plaintiff is entitled to sue for malicious falsehood, whether on proof of special damage, I think, or by reason of Section 3 of the Act of 1952, I can see no reason why in an appropriate case he or she should not recover aggravated damages for injury to feelings. As the Vice-Chancellor said in Joyce and Sengupta, justice requires that it should be so. Now, it's just a strange use of the word aggravated damages. And that might just be a way of referring to damages for distress. But clearly
I think it is, for what it's worth, I think it is. I was puzzled by this passage as well. There's a very good analysis of all this in the Law Commission report on aggravated and exemplary damages from 1993, which is the work of Professor Burrows, as it was. And I think that what he's really saying is injury to feelings. It's not quite accurate because, well,
But Sir Donald Nichols in Joyce and Sengupta, which must be the passage we've just been looking at 347 to 348, Joyce and Sengupta was saying that injury to feelings alone doesn't work, but, as he said, ought not the law to take such injury into account when it is connected with the financial damage inflicted by the falsehood.
Yes.
I mean, that's not reflected in what is said by Lord Justice Stuart Smith. What Sir Donald Nichols pointed out was that you can recover, or you should be able to recover, injury to feelings in an action in malicious falsehood, whether at common law or using Section 3,
Yes.
if it's connected with financial damage inflicted by the falsehood.
I would say that goes wider
What
than it
lie?
ought
I'm
to. It
just-
just,
when
if
I-
Section 3.1 is proven,
Well, okay, so let me...
the gate is open.
Let me try it again. Ought not, you can recover injury to feelings in a cause of action in malicious falsehood, whether under Section 3 or whether using the Section 3 or at common law, when it is connected with financial damage inflicted by the falsehood. And I'm just reading from what he said.
Yes. Can I take you to McGregor?
But the inference is, but not otherwise. You know, you can't. It's not a freestanding.
But the injury to feelings must arise from the publication.
Well, Sir Donald Nichols appears to think it must arise from the financial damage inflicted by the falsehood.
But if there is no financial damage, which will be the likelihood in Section 3.1 case.
Well, why would that be the likelihood? Section 3.1 case.
Section 3.1
Because-
applies if it is likely.
You're only going to be before the court in Section 3.1 case if you're seeking general damages.
Yes,
if
but
you're also seeking special damages,
You're assuming
you're going to have to
special
prove causation
damages
anyway.
means pecuniary loss, and general damages means non-pecuniary loss. That's not right. General damages could also mean pecuniary loss, but of a kind you can't precisely pin down.
Yes, and there's a passage in the Gleaner, which if I could take you to shortly, which deals with that issue, where the court is looking at something. It's not necessarily pecuniary loss, but it was in the Gleaner. The court just has to do its best. It's not special damages, but you can, to make the tort a tort of substance, a tort that achieves something, you can include that in an award of general damages. Just staying with McGregor, authorities bundle number 2.
But this is the difference between you. Sorry, before we just leave
Yes.
that going, this is the difference between you, isn't it? You say, if a statement is of its nature likely to cause financial harm,
Yes.
then using Section 3.1, it is actionable, and you can recover additionally for injury to feelings.
Yes.
The defendants say, but if we can prove that there was no actual loss, even though viewed prospectively it was likely that there would be financial loss caused by the statement, so you're into Section 3, but they say, no, as it turned out, there was no actual loss, then you can't recover for injury to feelings. You can't have injury to feelings parasitic upon no actual loss. That's the difference between you.
No. Well, it may be the
why
difference between us, but clearly I'm arguing against that. Section 3.
I go a little bit further.
Well, it's maybe not
Yes.
the only
It's one of the differences,
difference
yes.
between you, but that's certainly on this
Yes.
point.
The requirement for special damages are removed in its place is inserted Section 3.1. Then the court proceeds to award damages for damage that flows from the publication.
Yeah, well, you'd say you get an award of a monetary amount for the publication itself,
Yes.
and you'd say you get for injury to feelings
Yes.
as a freestanding head,
Yes.
irrespective of whether there's actually financial loss.
And for other adverse consequences, which I'll come to. Just staying with the law, McGregor.
But just, sorry, before we leave Corroborist and Shad, if we are, is your submission that that is binding authority that distress damages are recoverable in a Section 3 claim?
Yes, that must be
think it
right.
is.
That's part of the ratio.
It's binding authority.
Yeah. Because in that case, we can see from paragraph 34, the plaintiff did not claim special damage and relied on Section 3. An award of distress damages was made and was upheld by the Court of Appeal.
Yes.
So that's your submission.
Yes.
Well, was there also a claim for financial loss, though not special damage, in Code of Arrest and Law?
Sorry, 627C, page 98. reciting the findings of the trial judge.
Yeah.
Sorry, C.
C, yes, I think it's repeated elsewhere that she lost her employment, is now unemployable. So it's
That's it.
627C, there's a reference also at 631F, and also in the judgment of Lord Justice Cotton at 632D. So you can see the attempt to calculate the loss suffered,
Yes, thank you.
notwithstanding that it was a Section 31 claim.
And it's not special.
So,
It's not special.
Hang on one second.
yes, I mean, sorry, I quite see why you say, and it seems to me, with respect, right, that Credit Pressed and Shad is authority for the property. It basically makes ratio what in Justice Gupta was only obiter, that in a Section 3 case you can get damages for injury to feelings. But it doesn't address the question whether you can do so where there has been no financial loss, because unless the passages to which Mr. Price has just referred us are wrong, there clearly was financial loss there, though there wasn't special damage.
There was financial loss that fell short of being special damage.
Yes.
So the court engaged in that exercise, looking in the round at the damage caused, and came to the conclusion that an element of the general damages would compensate for that indefinable
But so do you
loss.
accept that it follows that Credit Pressed and Shad is not authoritative on the particular point which was being debated with you earlier, namely whether you need financial loss before you can have injury to feelings, because that problem didn't arise in Credit Pressed.
Yes, well, it's all I can say, that's our contention. And if you start stipulating that a claimant of facts such as this has to set out a case on actual financial loss, you end up in the situation that Section 3.1 was designed to avoid.
No, because that in Credit Pressed and Shad, she didn't do that.
No, but
You don't have to prove specific financial loss in a pounds and pence
yes,
quantifiable way, but the case against you might be you do have to prove financial loss of some kind, albeit under the head of general damages rather than special damages.
you don't have to, but you can.
Yes, I see. Right, thank you. I'm sorry, you were about to say something else.
The very last paragraph from McGregor I'm going to rely on. Authorities Bundle 2, tab 46. Page 992. you'll see section 3.1 is quoted at the bottom of the page. Then over the page, the author says this: the present position is therefore this. With statements falling within section 3, the claimant need not allege and prove specific pecuniary loss, as the court will infer the existence of pecuniary loss, and the damages will be at large in a similar sense to that in inducement of contract.
Sorry, where are you reading from?
From page 993,
Oh, no.
at the top, just below the quotation setting out section 3.1b.
Very odd. You heard the last sentence. With statements falling outside section 3, the claimant must still allege and prove specific pecuniary loss, although the court will be satisfied with general evidence of such loss where this is all that circumstances of the case will allow. I thought that was exactly what special damage, I thought that was the whole reason why section 3 was introduced, was because that wasn't possible.
It's a peculiarity. I don't see a footnote there. But the proposition.
Evans, isn't it?
Pardon?
I think that's Ratcliffe and Evans.
I think that's a pre-1952 case.
But that's
where the court would say that liability might be established if as a matter of fact, there's a falling off of business. But when you get to the general damages stage, you can't specify it in terms of pounds. You just make an award of general damages.
It's actually, as my lord says, that is really Ratcliffe. Well, it comes back then. What were the technical problems? If Ratcliffe and Evans allowed a very general approach to proof of special damage for the purpose of malicious falsehood, what were the technical difficulties which were causing all the problems?
Because even under Ratcliffe and Evans, you had to prove financial loss that resulted from the publication, even though you couldn't prove it to the extent of quantifying it in terms of pounds, shillings, and pence, as they would have said there.
So, why are you showing us why have you just showed us that little paragraph beginning the present position is therefore this? That's only dealing with pecuniary loss, isn't it?
Pardon me?
It's the next paragraph is what I would take the court to.
Well, I know, that's the point I'm just about to make. I mean, this all is under the heading of pecuniary loss. It's only addressing the question of pecuniary loss.
Well,
Because quite clearly,
the heading is one thing, but the sentence begins with statements falling within section 3. So that's what the author is dealing with.
yes, but this is in a little. This is part of a paragraph 48011, which is dealing with pecuniary loss.
Yes.
And then the authors go on to deal with non-pecuniary loss, such as fringent feelings, etc., in the next section. I'm struggling at the moment to understand why you've taken us to this at the conclusion of a debate about injury to feelings.
Well, pardon me, perhaps I should have made this point earlier, but what I'm relying on is the conclusion reached by the author there, which is clearly does concern section 3.
Yes. But it's not dealing with the questions that Joyce and Sengupta or Code of Arrest raise, which is what we've just been looking at, because that's clearly, isn't it, the subject of the next series of paragraphs, 48, 12 through to 15.
Yes, it's fundamentally we're saying if section 3.1 is satisfied, that's the basis for the award of general damages. Raising that issue doesn't necessarily segue into Joyce and Sengupta, but it does form part of our submissions as to how section 3.1 works.
But when it says therefore in that paragraph, you just showed us that damages will be at large. Are you suggesting that means that the author thinks that damages for loss of feelings, distress, are included within that?
Yes, it's certainly part of our case, and at large is all encompassing.
So in fact, we could just strike out paragraphs 48.12 through to 48.15 as surplusage.
With all respect, my lord, I'm not saying that.
Okay. So should we read? Well, perhaps we're going to be asked to read the paragraph.
Well,
Really loads of, while we're here, I mean, it's stated explicitly halfway down 48.12 at the end of sentence starting section 3. You can see the sec. I mean, states the position clearly.
You're saying that everything you can get. So the contention that Mr. Price you're making, as I understand it, is that you can get damages for injury to feelings or distress, but only parasitic upon.
Yes. And it's pecuniary damage.
Pecuniary damage.
Yes, and one can even considering damages without pecuniary damage having been suffered or likely to be suffered, because that's the essential element of the source of malicious force of whether special damages or claims relying on section 3.1, as stated clearly in that passage.
Yeah.
my lord, I did promise Mr. Price I'd finish my submissions by 1:45. It's inevitably happened. I'm going to have to concertina some of those submissions.
Well, I did promise to him it would be overridden by us.
Very well.
We've given you a bit of a runaround. On the other hand, I think we have covered an awful lot of ground, if not always in the way that you intended.
Yes.
What have you still got to do?
Well, what I want to do is look at the facts of this case. The facts are in issue. Even though quantum hasn't been determined, Mr. Price is saying there's no real and substantial tort, and this appeal really is all about costs.
But even if that were right, why would that be a reason for it not being? Well, it's a perfectly viable appeal.
Yes. But I think what he's saying is, and it's not in his respondent's grounds, that even if we win on the appeal, that will be what he would describe as technicality, and the case ought to be struck out by this court.
Well, there's no
And not be
application.
rewritten. No, there isn't. But what I am going to do is deal with the facts briefly, because I do think when one's dealing with a statute for the first time, an examination of the facts really bring to life why and how this statute ought to operate. I'm just going to rely on findings made by the judge in his judgment and evidence that contradict it.
Just give me 1 moment. Yeah, well, of course, we're not going to stop you drawing our attention to 1 or 2 points in the facts which you say illustrate or how the point of law, which is all we're really concerned with in this appeal, works out. I agree that can be illustrative. But we have read the facts.
Yes.
So I really don't think we need to be have any detailed submissions about them. Insofar as you're concerned about submissions that Mr. Price you think he's going to make, I think that's better dealt with in reply. At the moment, the attack which you say you want to meet, I'm not sure is one that's open to Mr. Price, but if in the end we're persuaded it is or might be, we will allow you time in reply.
Yes.
So on that basis, I think you ought to be able to make good your promise to Mr. Price.
Yes. Well, our submissions on the law are complete. I'll ask Mr. Pasuto to find the reference to the Gleaner for me. I'll just give you the paragraph reference there. It's a principle.
56.
paragraph 56 of the Gleaner. Very clearly, it's the principle.
Of the Gleaner case.
Yes, it's Privy Council case.
Yeah, no, I read it. Yeah.
Yes. Now, just briefly on the facts. Why is it that Section 3.1 ought to operate in the way contended by the claimant in order to do justice and in order to put Parliament's intention into effect? The claimant started work at Fawkes and Rees on the 3rd of January 2019. She started contacting clients who had also been the clients of the second defendant. She was perfectly at liberty to do so. There was no contractual term stopping her from doing so, and it was commercially reasonable for her to do so. The first defendant, the owner and manager of the second defendant, took exception to that and concocted what's found to be a malicious plan with her legal advisor to deceive Fawkes and Rees about the false existence of a contractual term which prevented Miss Fiona George, the claimant, from contacting those claimants. The defendants were seeking to make a commercial advantage for themselves and to put the claimant at a commercial disadvantage. As Mr. Justice Saini says, this wasn't the spur of the moment matter. This was malice, a forethought. This was a premeditated plan in action to lie. There can be no doubt about that. It's a conclusion Mr. Justice Saini reached at the end of the evidence. Within 2 weeks, or just over 2 weeks of starting her employment, the first defendant put her plan into attack. That's on Monday, the 21st of January. The first defendant spoke to Matthew Butler, who was employed by an estate agent called Balgore. And the defendant knew that the claimant was trying to get work from it. Now, shortly after that, at 4:30, Miss Cannell sent an email to Fiona George, that's quoted at paragraph 77 of the bundle. And it accuses Miss George of proactively seeking out the clients that also used the second defendant and tells her to stop doing it immediately. And if she doesn't do so, that she will sue Miss George.
That's not one of the emails.
No, it's not complained of, but it's in order to understand the case.
Well,
you need,
we
you
do
need
understand the case.
But then Miss George receives an email from Mr. Butler, which outlines what he's been told by the defendant. It's ultimately a case of spoken words, but the judge accepted that that email shows what the first defendant had said to Mr. Butler earlier that day. So Miss Fiona George has received that email. She's received the email sent directly to her, which of course isn't sued on. That all happens within 5 minutes. At 4:37, she goes to Graham Lingenfelder and she explains what happens to him. She tells him she's not bound by that contract because it doesn't exist. She tells him about what's happened with Mr. Butler. So the words to Mr. Butler feed through into the effect of Mr. Lingenfelder. Now there's evidence of distress which isn't contradicted, hasn't been cross-examined. We say that's obviously corroborated by the position that one can see that Miss George was in at this time, a time of massive distress. Now, because she mitigates her damage, this leads to the finding by the judge that, in fact, Mr. Lingenfelder, her employer, knew that, in fact, she wasn't bound by the contract. And that's really the end of her case in defamation, because that requires serious harm for defamation. But the nub of a malicious falsehood claim is that pecuniary damage can be caused by other means. And what happens is Mr. Lingenfelder immediately tells Miss George to ring-fence clients with whom the second defendant has dealt with before. So immediately you see an economic impact upon Fiona George. She's forbidden from contacting those clients. And she said in her witness statement that it's not contradicted. She was on a low salary in the region of £20,000 or so. She depended upon commission. But those clients were ring-fenced as a direct result of what Miss Cannell, the first defendant, did.
I'm sorry.
Now,
I've read all this and I see it, and I've got no difficulty in understanding distress. But what point are you making from these facts?
well, this goes
Because you're saying there's pecuniary loss,
yes.
but that's not part of the appeal. You're not actually saying there was pecuniary loss. So how's it helping us to have these points?
This is the exercise where the court does the best it can to award damages.
But we're not being asked to do so, are we?
Well, what I'm trying to establish is this is why Section 3.1 needs to work in the way it does in order to protect someone like Miss George in this type of scenario. Because what happens is her special damages claim is knocked out on issues of causation. Because it so happens she goes on to get a better job, albeit in a different sector, because she escapes this area of work. Because, I mean, let's not mince our words, she was in effect being terrorised by Miss Cannell by these actions. This isn't the sort of claim where Voltaire would say, I disagree with what you say, I defend to the death your right to say it. This is the use of words as a weapon to inflict commercial harm upon Miss George to the advantage of the defendants. There's much talk in Mr. Price's skeleton argument about his client's Article 10 rights. We say they're absolutely at rock bottom, at zero, because at the point and before publication, she knew what she was saying was false.
Can I just check on the facts, something you just said? I think you said that Miss George's claim was knocked out, at least as far as special damage was concerned, because she, in fact, got a better paid job.
You're right, my lord.
And how does the commission, feed into that? Because your previous proposition was that you could see that because you depended upon commission, the ring fencing of the clients would have caused her some financial harm because of the inability to earn commission from those ring fenced clients. But isn't that swept away if the proposition is that she went on to get a quote better paid job?
Yes, well, that's one of the problems with causation. What I should say, to be fair to the judge, he found that Miss George resigned because she feared that these words were being alleged spoken in the industry generally. Clearly, the first defendant said that. That's part of the case on malice. But what I think this demonstrates, you look at the 4 or 5 days of torment that Miss George had to undergo. And she gives evidence. I commend her witness statement to you from about paragraph 94 onwards, which isn't contested on this ground. Now, clearly, you're right to say, well, the issue on that is solved by the fact of just saying, well, she gets injury to damages. But we say this should still be factored into the award, this effect on her, regardless of the distress caused, because it disrupted her work and ultimately caused her to resign from her employment. And whether you say the resignation was caused by the threat ultimately not carried out by Cannell to contact everyone in that industry, at least all the second defendant's clients, that threat was hanging over the claimant, and that threat was informed by the fact that she'd received the email from Mr. Butler, the email from Miss George, and that her boss, her line manager, Mr. Lingenfelder, had also made the allegation to her. So the situation seemed hopeless.
But is this a timing question? Is your case this, that initially when the falsehoods were communicated to her employer before she resigned?
Yes.
At that stage, if you stop the clock, you would say they were likely to cause her financial loss in her profession?
Yes.
As far as one could guess, they would have caused her financial loss in her profession because she was told, just don't deal with those ring-fenced clients.
Yes.
Which would never have been done had the malicious falsehood not been uttered. And at that stage, she was distressed. So she would be entitled on the face of the authorities, you'd say, to recover damages for distress. You say that shouldn't all be wiped out. All of it shouldn't be wiped out by the happenstance that after she resigned because she felt she had to, lo and behold, she had the good fortune to get a better paid job.
Yes.
And you say that's not what Section 3 is designed to do. Is this a timing question? I mean, is that the way it plays out?
All I'm saying is that should be factored into the award of damages. What happened during those days? It's just not a question of injury to feelings. The court ought to take account of what happened and compensate, using the expression, doing the best it can, for the fact that the defendant's actions contributed.
The point I'm making to you, and it may be that you don't kick this gift horse in the mouth particularly hard, is that the injury to feelings for which your client is seeking compensation, when suffered, was consequential upon financial loss, which Section 3 is designed to enable her to sue, even though she couldn't specifically identify it.
Yes, it's not dependent on financial loss. I still stay with my primary submission. She doesn't have to prove financial
I know
loss
what
to
your
get
primary
distress.
I know
But
what your primary one is.
if you look at what happened, clearly what's happened is her commercial life is being sabotaged. She's having to change jobs.
Yes, but in legal, let's keep in legal terms, she suffers actionable, you say, non-pecuniary loss through distress.
Yes.
At a time when she has also, because of Section 3, the ability to bring a claim based on Section 3
Yes.
for financial loss.
Yes.
The fact that subsequently she has the good fortune to get a better paid job, you say, doesn't extinguish her ability to claim injury to feelings.
Yes.
Even though it might result in her not being able to claim financial loss.
Yes. I mean, one could see the example, for instance, if a teacher were the subject of a malicious falsehood, and the malicious falsehood was directed wholly at the teacher's ability to teach children, and the teacher is driven out of the profession, but it so happens gets a higher paid job in commerce, the damage in terms of general damage would be very significant indeed, whilst the financial damage would be, in effect, be negative. Should be financially better off in getting a new job. And this is the type of claim that Section 3.1 catches, and which enables this court not only to put into effect the meaning of Section 3.1, but put into effect what it's designed to achieve. And that goes back to the words of Parliament, whether that's persuasive or not, but the words are words of wisdom. This is about doing justice. And Section 3.1 provides a means for doing that in regard to people like Fiona George. And just to leave you with paragraph 91 of the judgment on appeal. That's page 95 of the core bundle of tab 7. You'll see there's a quote, Mr. Lingenfielder is informed by the first defendant. Pardon me, page 95 of the core bundle.
You mean 95?
95.
Sorry, that's fine, yep.
You see in paragraph 91, Mr. Lingenfielder is told by the first defendant that really he's lucky that Fiona George has resigned. He's so sorry for the delayed response. I've just located your emails in my junk folder. I just wanted to thank you for your open, respectful communication in respect to Fiona and of your business interests. Given the information provided to me following Fiona's departure from LCA, separate from the post-employment issues, I feel you've had a lucky escape. And then Mr. Lingenfeld, as the employer's frank response, we say is telling. Filing, thanks to the reply, and yes, it certainly does appear to be that way. I did make it clear to her upon starting that she did need to avoid any clients. And we say there's plenty of evidence to the effect that she was contacting clients who'd previously used D2, and there's nothing wrong with that. But it fell on deaf ears. Quite a lot of time wasted in the past month, which was disappointing. But like you, I say I've probably saved myself a lot more time and hassle in the long run. Now, what this shows, where you haven't got a case of defamation, is again the dislocation to the employment here and the situation faced by Mr. Lingenfelder, who of course was told in the email sent to him by the first defendant that he needed to stop Fiona George from dealing with clients who also dealt with the second defendant. As a matter of reality, Mr. Lingenfelder was immediately presented with a problem he shouldn't have had, and a problem that caused him to ring-fence irrelevant clients. And immediately, by the actions of the first defendant, the employment became problematic, whether Mr. Lingenfelder believed the allegation or not. And you see that, and he says, well, at least I've saved myself a lot of time and hassle. The hassle was created by the first defendant, and it only came to an end because Fiona George felt she had no alternative but to resign from her employment. Lastly, I've quoted, I think, paragraph 77 of the skeleton argument, what we say are the prescient words of Mr. Justice Spearman, who heard the original meaning hearing in this claim when it was still also a libel claim. And I won't take you to it, it's paragraph 77 of the skeleton, where he said, well, in a situation like that, employer is going to be faced with damaged goods. Once someone's going into the market, or saying they're going into the market, and telling the employer that the employee cannot contact clients who the second defendant's contact, that creates exactly the kind of hassle that Mr. Lingenfeld talks about, and again disrupts both Miss George's commercial standing and her ability to act commercially in a job in which she'd been in for barely over 3 weeks before these events caused her to resign and seek employment elsewhere. And it's 2:15, but I'm just going to throw in one of the authorities that Mr. Price put before the court, which you'll find in the authorities bundle number 2 at tab 48, is Queen and Brent. That's authorities bundle 2. It's gone into the end of the second bundle.
I've only got 47.
Oh, well, Mr. Price, if I can just give you the reference. Mr. Price, I think, is seeking to rely on an additional authority.
Well, that hasn't reached us, Mr. Price. So did you send it to the court?
Yeah, I did send it to the court.
I've got it.
I've got some copies here.
I'm sorry. Well, it didn't reach me. I don't know why. But
I think it came with your notes, didn't it?
Yes, I mean, I just thought.
Well, I haven't got your note either. Oh. What note is this?
This was a note on why I was sending it to authorities. So I thought Mr. Bennett might want to rely on them. And so.
Well, there's obviously been some confusion. Have you got the note?
I've seen the note. I just haven't got the authority to bundle either.
Well, look. Sorry. Let's just. I don't. When was this note sent?
Friday.
By email?
By email. I got an acknowledgement from the Lord Justice Warby's clerk.
Yes, I was away last week. There's obviously been some failure to get it to me. Have you got a hard copy there of the note and the authorities referred to?
I've got a hard copy of the authorities.
I can.
Well, I'll pick up the note later. I better have the authorities now, haven't I?
Yes. So the first one is the one that so Mr. Bennett's about to mention, which is Kadim. It's a case of involved.
Oh, I was puzzled by the repeated references to Kadena. Yes, okay.
I think, my lord.
Well, look, don't worry about that. Just let me have the bundle.
My lord, I'll make my point in reply.
Sorry about this.
No, I might.
Well, it's not your fault at all. You obviously sent it to the right person, but it didn't come to me. But
No. Another one. And there's a case called, another case called Must.
well, don't worry. Just give me the authorities.
I'm going to give it to you right now.
Look, there's some confusion here. Can you not just give?
Authorities now, and,
If there's a problem,
yeah.
is it clear what I'm supposed to have?
Yes,
Can they not then just be given to the associate?
Yes, I will. I was just looking for a further authority, but I will give those authorities now. Give that one. Have you got 3 copies?
We don't need 3 copies. I'm the only one who hasn't got one.
Okay, just 1 copy.
Oh, I gather
We need 2.
we need 2 copies.
2 and 2 of these. Sorry. I do apologise. 2 of these and 2 of these.
Thank you.
So the note, Kadim and Stuart Brady.
Yes.
It's just for me. What is this note? Thank you very much. Sorry for the confusion. Okay. Can I just ask one thing so I've got this clear in my mind? Suppose we are with you on your primary position that on the judge's findings a cause of action was made out here.
Yes.
So the appeal succeeds. 2 questions would then arise. One, whether the case needs to be remitted for assessment of damages. On the face of it, it clearly does. But one answer might be that the only damages to which you're entitled is nominal damages, in which case there's no need to remit because we can award nominal damages as much as the judge can. It seems to me to follow from that that you do need to persuade us of the points that we have actually canvassed with you, that there is at least arguably further heads of damage, substantial damages available to you. Yeah. I'm just trying to get this structure in my mind. So this isn't. So this is actually integral to your case because if we're not persuaded that that is so, we don't need to remit. With me so far?
Not completely.
Sorry, at one point I thought, it may be my misunderstanding, that you thought all this question of whether you're entitled to any other damages was rather secondary. It wasn't really what this appeal was about.
Would this appeal is purely about liability?
Well, that's just what I'm teasing out. It's not really purely about liability because it's essential to the consequential. If you win on liability, there's a second question for us, namely, do we remit?
Yes.
And if you're only entitled to nominal damages, there's no need to remit. Therefore, you need to satisfy us that you are entitled to more than nominal damages, though not any particular amount, but just as a matter of principle. Do you accept that?
I think there's a real prospect of substantial award of general damages.
Yes.
Yes. So now I don't think it's a problem because we've actually been over all this with you, seen how you put your case. But it seems to me that that is actually an integral part of what we have to decide, because otherwise we'd simply decide if it's not enough for you to get liability, you also need to get a remission for substantial damages. Then the second thing that would or to argue your case for substantial damages, the second thing we have to decide, you would say even if you only got nominal damages, nevertheless, that would have an impact on the costs order.
Yes, most definitely.
But that's not something you've addressed us about, and presumably what you would say is you would address us about it once you knew whether it was going to be remitted for
Yes.
well, that makes sense, I suppose. So you want to address us about that once you know the outcome, effectively, as part of the consequential submission.
In stages, yes.
Okay.
All I can say in terms of nominal damages versus real and substantial damages, we've set out our case. It's the award of damages for injury to feelings isn't contingent on establishing that there is financial damage. But even if you go down that road, if you look at what happened in those 4 or 5 days after publication, that's the type of damage that was being inflicted. It's commercial damage to the advantage of the defendants, to the disadvantage of the claimant. And that, we would say, the gateway to injury to feelings damages is merely the satisfaction.
Well, we've been over all this.
You have
I just wanted to get the structure clear in my head.
Yes.
It may be perfectly obvious to everyone else.
Yes.
But, right. Now, Mr. Price, perfectly willing to give you 5 minutes with the new board, if that would be helpful. But if you would rather start at 1 to 2, we'd be happy with that as well.
Well, if it's left to me, I'd rather start now. But
Yes?
This is appeal solely about statutory interpretation. There is no challenge to any of the findings of the facts made by the judge. And whatever interpretation that this court concludes is the correct interpretation will have to apply to all cases involving Section 3.1. All malicious falsehood cases would apply the same test in terms of what a claimant is required to prove. And it seems to me that there are 3 possible options of what a claimant is required to prove that seem relevant to this appeal. We start off with what is common ground and what is supported by Court of Appeal authority, which is this: that calculated means more likely than not.
Sorry.
Calculated.
No, you confused me. I thought you were about to give me the 3 possibilities.
I'm going to, but I'm just starting off with what's not an issue.
Okay.
So calculated means more likely than not, and this must be judged objectively. So the 3...
Must be objective.
Yes, so the 3 possibilities relate to what is it that must be more likely than not to occur, and which is to be judged objectively. And they are set out in my skeleton argument, page 51 of the bundle, but I don't know if you have a skeleton argument freestanding.
I do.
I brought it loose.
It seems to me that these really are...
So where
Page 51 of the bundle.
Well, if we've got it freestanding.
Sorry. Yes, it's
Which
page 2
paragraph?
of the skeleton argument. It's paragraph 1.1 on the second page, page 51 at the bottom.
Hang on, let me just see.
These are the 3 possibilities. The first one is that some financial loss has been caused by the publication of words complained of. And this determination is made by looking back from the date of the trial on the basis of any probative fact, including what occurred after publication. The trial judge asks, has any financial loss been caused? It doesn't have to satisfy the strict requirements of special damage, whatever they may be, and I appreciate that there's a question about exactly where the line is between special damages and general damages, but the judge asks himself, well, is it more likely that there has been some financial loss? It doesn't have to be any particular amount, but some financial loss, which is consequent on the publication of the words. That's what I've called the historic test. The second option is that some financial loss would be caused by the publication, and this determination is made on the basis of any probative fact in existence at the date of publication. So in other words, one freezes the frame at the date of publication, but one takes into account at that point all probative facts in relation to likely loss looking forward.
It actually would likely be caused.
Yeah.
Some financial loss would likely be caused by. It's not.
I suppose I linked it back to the more likely than not in paragraph 1, but yes, I mean
You could say it is more likely than not that some financial loss would be caused.
Yes, but
it's not an absolute.
Yeah, essentially you're freezing the frame at the date of publication, you're looking forward, but you take into account all the probative facts that already exist. So in this case, the fact that Mr. Butler had already decided he wouldn't want to have anything to do with the claimant for totally unconnected reasons, you take that into account. And you'd say, would these words make any cause financial loss to Mr. Butler when he's already decided?
But then you also have to take into account that, in fact, the claimant had ignored that, hadn't she?
But it doesn't matter whether the claimant ignored it. It's got to be on the mind of the publishee. It's whether it's impact of the falsehood on the publishee. That has to be correct. That's what you're considering.
Well, but you're not saying any probative fact in existence and known to the public.
No, it doesn't have to. Doesn't mean known. It's probative of whether that statement to that publishee, that falsehood to that publishee, would cause financial loss to the claimant. So it has to satisfy the normal test of whether it's probative or not. I mean, I'm just stating it as an abstract, and we can come to the facts in this case. But these do seem to me to be the only three possibilities. The court is going to have to determine which is the correct one. I've described that as the forward-looking from publication test, the forward-looking test. And then the third one is that the imputation conveyed by the words complained of, viewed in isolation, has a tendency to cause financial loss, and the court is prohibited from considering any other probative fact in relation to likely loss, such as the number of publishees or whether the words would or would like to have any impact on them. That's the tendency test. So that's the interpretation effectively contended for by the claimant. So long as the words in abstract are of the sort that would be likely to cause financial loss, then Section 3.1's test has been satisfied.
Okay, well, you've got your 3 propositions.
Yes.
And you've had your 5 minutes. You'll sit again at 2 o'clock.